Hi, Andy Nelson. Today I want to talk about a 10th way that you can torpedo your trademark rights. In this case in particular, a way to torpedo what would be your federally registered trademark or your trademark application. In this case, when you do apply for a trademark registration, you have to describe the goods or services for which or on which you've used your mark. And if you're kind of reserving a trademark, the goods or services you want to include or you want to sell under that mark. The thing is, you are making these statements under oath. So you have to, if you're saying, I'm going to use it on these products or services in the future, you're basically saying under oath, you have a bona fide intent to do so. And if you're submitting an application that's saying, I have used my mark on these goods or services already, again, you're saying, I've used it on these products or services under oath. Now, in my last video, I talked about over-describing and the danger there. However, by the same token, or on the flip side, there can be a danger in under-describing your goods or services. Now, is there a problem you're going to make a misstatement? Maybe set yourself up for fraud or a finding of fraud and canceling your trademark registration from under-describing? Probably not. But the danger in under-describing rather, a lot of syllables there, is that you are not giving yourself as much protection as you deserve. You have an asset here. Your trademark that you build rights in is an asset. The trademark registration is an asset that goes along with it. I mean, a lot of people might treat them as the same thing. I think they're kind of two things that go hand in hand. Whatever you use your mark on is really kind of the scope of the asset. The registration, though, is kind of evidence of it and may even give presumptions of it if you have to enforce your trademark in court somewhere. But the contents of that registration mean something. And if you've used it on all sorts of products, but your registration lists one of the five, you could potentially have problems or extra challenges, I should say, enforcing the rights against somebody else. Because let's say, I'm in the abstract here, but let's say you've got one of really kind of five general categories or fairly specific products or services that you've used your mark with. Someone hits dead on one of those, but you don't have that listed in your registration. You don't have a presumption that you've been using it with that product or service. And now you got to prove it. And so if you have to prove it, that can be challenging. You say, well, that's no problem. But you know what? Going back and finding documents and going through emails and just data, it's time consuming, and it just makes it subjects it to more scrutiny, makes it more trouble. So the moral of the story is be accurate. Don't over-describe like I talked about in my last video, but don't under-describe. You want to describe fully. Now, you can do that yourself. You may need a professional to help you describe things accurately, especially the more complicated your products are. If you're describing, you sell pants and you sell t-shirts and things like that, that's not hard. But if you have some kind of digital service or other sort of complicated service that has a lot of elements to it, you may be best served by getting some help in describing that fully so you are completely protected. And again, it's an asset. You want to maximize the value of your asset, so you want to describe your goods or services covered by your trademark registration accurately. Simple. Anyway, that's it. If you have any questions about this video, shoot me a note, drop me a comment. And if you know someone who would benefit, and I bet a lot of people would benefit from knowing this, everyone wants to maximize the value of that intellectual property, please feel free to share it with them. Until the next one, have a good one.